In this video, I am going to be showing you how to cross-examine the other party at a restraining order hearing when they're lying, but you don't have any hard evidence that they're lying. My name is Veronica. I am a criminal defense and domestic violence restraining order attorney here in California, and I help people who have been arrested or served with a restraining order put their case behind them so that they can enjoy their lives and their freedom. And I am especially excited about this video because what I'm going to be showing you today is something that I am teaching in a new course called Defeat the DVRO. So Defeat the DVRO teaches you from A to Z in simple, easy to understand language what to do to try to defeat a restraining order when you have been served with one. So in other words, when you are the respondent. It will give you exact scripts of what to say, explain how to get your evidence in, and show you some techniques like the one that I'm about to show you on how to demonstrate to the judge that the other party is lying even when you don't have hard evidence. So let's get right into it. All right, and just to give you some context, in the course I teach 4 different cross-examination styles. So this is the first one, and I call it, if that were true, then this would be too. This is where you ask questions about actions that the petitioner, that's the other party, that's the party who filed the restraining order, actions that she would have taken or evidence that would exist if her story were true. And you use this when a witness describes this far-fetched or untrue scenario that you can't necessarily disprove with cold, hard evidence. You know, it's hard to prove that something didn't happen, or it's hard to prove a negative, in other words. But you use this when the witness has little to no supporting evidence to back up whatever they're saying happened. Okay, now here's how to do this. And this part is arguably the most difficult part, but once you get the hang of it, once you kind of understand what to do, then it will get a lot easier. So what you're going to do is imagine the scenario that the witness is explaining. Imagine that you're there. You are in the witness's shoes. And imagine everything that they're saying is happening to you. Just take a minute and try to transport yourself there as much as you can. What would you do in that position? What would most people in that position do? You know, if you're especially brave or especially smart or whatever, don't take that into account. What would most people do? What would the judge expect, perhaps, a reasonable person in the witness's shoes to do? And most importantly, what kind of evidence would you expect to come from this scenario? Because remember, this is to be used when the petitioner, when the witness really doesn't have any other evidence. So think about that. It could be a 911 call. It could be a police report exists. It could be somebody saw injuries. It could be calling, or going to the doctor. But think about all of those things, at least maybe telling a friend if it's a terrible scenario afterwards, and then she would have a witness here with her today. Think about all of that. And then this is the question format that you use. And throughout the course, I give you word for word exact scripts of what to use. You just fill in the blank. So step 1 is you testify that. And what you're going to do there is insert the fact that the petitioner testified to or wrote in her DVRO there. So ideally an exact quote. So where you get this, as the respondent, as the person who served with this restraining order, obviously you might feel like you have a lot of disadvantages, right? You didn't get a chance to say anything. You were served with this document. It sucks. You probably had to move out of your house if you guys lived together. It really, there are quite a few disadvantages, but one advantage that you have is that the petitioner had to write down their story. So if you look at something in there and you see, look, if this really happened, let's say she says I pushed her down the stairs and broke her leg. She would probably have to get medical treatment, right? And if she didn't, and she didn't bring any proof of it with her, and if it didn't happen, right, that she never got, none of that proof exists. You have an advantage because you can prepare in advance for this. So either it's exactly what she wrote in the DVRO, or an exact quote if there's something brand new at the hearing and you can write it down. You can paraphrase it if you need to, if you can't write it down fast enough. But that's where you put it. So step 1, you testified that, and then insert the fact. And then step 2 is there are two different versions of this. The first one is missing action. So you didn't, and then whatever action. So call 911, for example. Version 2 is missing evidence. So you don't have, didn't bring, didn't take photos of whatever the missing evidence is. So a photo of an injury is a big one. And you just keep repeating step 2. You don't have to do step 1 again for this same scenario, but you want to repeat step 2 until you have gone through. Don't go crazy with it. Don't annoy the judge and don't make it seem like you're badgering the witness. But until you get, those big pieces of evidence that should probably exist if her story is true. And I'll just say, I include this disclaimer in the course, but I say she here because it is commonly women who file these domestic violence restraining orders. That's not always the case. It can be a man, it can be, 2 men that were in a relationship, it can be 2 women, it can be whatever. I'm just saying that so that it doesn't get confusing with saying they in some of this. Okay, so now let's go through an example. So if she claims that you once pushed her down during an argument, causing her to fall and scrape her knees, but she didn't call the cops, didn't seek medical attention, and has no photos of her injuries, then you ask, so step 1, you testified that I pushed you down and you scraped your knees. That part is step 1. And then step 2, you can see that there are 5 questions I ask here. You didn't seek medical attention, did you? No. In reality, you wouldn't necessarily seek medical attention for scraped knees, but you might. You didn't call the police. You didn't take photos of your injuries. Now, that's a big one. We all have our cell phones. We're all taking pictures of everything. Even if you're really scared, you might still, when you're going to the bathroom, putting Band-Aids on, whatever, might take some photos of your knees. So that one is kind of suspicious here, to not even have photos of that. You don't have any witnesses that saw this happen. Okay, well, that one, it's worth asking, but, people are obviously, if it's just 2 people in a house, there are not going to be any witnesses. But then you didn't bring any witnesses today that saw your injuries. So imagine you fall and you scrape your knees. You're going to, at least for maybe a week or so, you're going to have a skinned knee. So for especially people who wear like a lot of shorts, dresses, probably somebody is going to see something there, that they're going to see either a bandage or an injury. Now, be careful. Don't ask why. Don't ask why you didn't call the police. Don't ask why you didn't take photos of your injuries. This is something that they teach us in law school, and that is really important. People are tempted to ask, why didn't you? But what you're doing then is you are giving the witness a chance to explain themselves. And you know what they're going to say. They're going to say, I was too scared, or I loved him and I wanted to stay with him. I didn't anticipate ever having to file a DVRO. You're just giving them a chance to explain themselves even more. And judges will give a lot of leeway to alleged victims who didn't call the police. Now, one final thing is, if the judge seems to be getting impatient with this, and make sure that you don't say it in a badgering way, then limit it. So when I was going through these, I explained some of them may be better questions than others. Some of them may be more important. I think that the most important ones here are, you didn't take photos of your injuries, and you didn't bring any witnesses today that saw any injuries. I think that those 2 are the most important, because those 2 are things that, if this scenario had actually happened, you would expect that one or both of those things would likely be true. I hope that you found this video helpful. You can go ahead and click, if you want to take the full course, you can go ahead and click down below. You can see the introduction to the course for free right there, and see if this is something that maybe would be helpful for you. These DVROs, they are intimidating. There is a lot at stake, but they are winnable, especially if you have the evidence on your side. It's a matter of knowing what to do, knowing what to say in court, and feeling confident. You don't want to go up there floundering around, feeling like, you have all the evidence, and if only you could present it to the judge and show the judge what you know that's maybe on your cell phone, then you could win this thing, but you don't know how to do that. And so then you end up losing and having all these horrible consequences just because you didn't know what to do, or what to argue, or what not to do. So that is exactly what I explain in the course. And, there are resources out there for people who claim abuse and people who were abused. There are tons of resources out there, but for people who are responding to one of these, they're just not there. So that is exactly why I created this course.